have a couple of motions to hear. And I understand first, Ms. Kibler, you have, there's a motion that has been, or there's a grievance that has been withdrawn, if you want to speak to that for us.
Yes, ma'am. Good morning. And if I may also take the moment to introduce the newest member of the City Attorney's Office, who is Isaac Ridgway. He's joining us today. Mr. Ridgway and I will be back to see you in October with Mr. Jeffrey's grievance. But this morning, I wanted to let the commission know that at about 7:30, we received an email, I believe you were copied, Madam Chair, noting that Mr. Motley, who had filed a grievance back in 2019, has asked the commission to withdraw his appeal. He's indicated in that email that he does not wish to proceed. So I'd simply ask that the commission note in its record and minutes that this appeal has been withdrawn, and then we'll close our file on the matter.
All right. Thank you. And I think that we can ask the city clerk to make note of that and proceed. Before we get started on the next matter, I think it's a good idea for those who are not familiar with the commission for us to introduce ourselves. And so, starting with you, Mr. Moore, if you would just introduce yourself, and we'll come left to right and identify ourselves.
Yep, I'm Alex Moore.
Hey, I'm Phil Rubin.
I'm Manu Lee.
I'm Denise Klein.
I'm Trish Holland.
And I'm Tom McCormick. I'm not Cynthia Ball.
All right, we have then two matters remaining, as I understand it, to hear today. We have a motion to dismiss on the Richard Coates matter. We also have two matters in one case. There's going to be a motion to dismiss and a motion for regarding subpoenas, and we'll take that up next. But let's go ahead and hear the Coates matter.
Hey, Ralph, did you have printouts
Yeah,
for me?
that's fine. Mr. Seymour, hey, Robert, where do you want your client?
He can just come sit right
Okay.
here. Is that all right?
Good morning.
Your handouts for everyone. I have to thank Beth Svensgaard in my office for making. You know that notebooks were hard to come by with the cases we had this morning. What I'm passing to you is the city's motion to dismiss, copies of all the exhibits that were attached to the city.
Did you need one of these? I think I have one. Merry Christmas.
Oh, okay. Okay, Ralph tells me I'll need to be at the lectern to use the PowerPoint.
Okay.
So if that's okay with the commission, I'll.
Okay, all right. So if council will first introduce yourself, Mr. Crawford.
I'm Robert Crawford, Wake County Bar, representing Captain Richard Coates of the fire department.
Okay, thank you.
And Andrew Seymour, with the Raleigh City Attorney's Office on behalf of the City of Raleigh.
Do we have anybody remote for this that we need to make sure we use these, or we're good? Okay. What's that? Sure.
So, Mr. Seymour, when you're ready, this is your motion, and you can proceed.
Okay, where is Outlook? Ralph, how do I access presentation, web, email?
I think they're ready. Is that not? No, Where's mine? And,
Okay.
excuse me.
Thank you, Dottie. I apologize, Commission members. Oh, okay. There I am. I'll speak up. So may it please the Commission. As I mentioned, my name is Andrew Seymour, and I represent the City of Raleigh. We're here today on the city's motion to dismiss. So we're here today because petitioner Richard Coates was arrested for a DWI. And he's now challenging the fire department's policy, the fire department's DWI policy, which says that any RFD employee who's charged with an impaired driving offense, like a DWI, is subject to a 10% pay reduction during the pendency of the case. In his appeal to the commission, petitioner raises various policy arguments, equity arguments, and complaints about the policy. But what he doesn't do is allege any violation of any applicable city policy. And that's what we look for whenever there's a civil service hearing. The board is a commission, or the commission is a board of limited jurisdiction, and it can only decide those matters in which the Raleigh Civil Service Act authorizes it to. Because Mr. Coates' appeal does not invoke the commission's jurisdiction, the city asks that it be dismissed. So before I lodge into my argument, I'll give you a little bit of background to the case, which essentially are undisputed facts. Not essentially, they are undisputed facts. So Richard Coates is a captain in the fire department. As a captain in the fire department, he's in charge of the entire firehouse during his assigned shift. Fire captains are supervisors, and they're required to maintain a valid North Carolina driver's license. On November 1st, 2019, petitioner was arrested for drunk driving in Carteret County. A copy of that DWI charge is attached is enclosed as Exhibit 4 in the city's motion exhibits. At the time of his arrest, the fire department had in effect Administrative Policy 101093, impaired driving offenses. I'll refer to this morning as the DWI policy. And a copy of that policy is also enclosed as Exhibit 2 to the city's motion. Under Section 5.1 of that policy, it states that in 5.14, an RFD employee charged with a DWI shall receive a 10% reduction in salary until disposition of the case. On the next page, at 5.33, it states an RFD employee who has DWI charges dismissed will be eligible to have their salary reinstated to his or her regular salary rate. Now, I want to point out that there's no dispute that Mr. Coates, after his charges were dismissed, that he had his salary reinstated. What the issue here is the salary that he claims he's entitled to from the time that he was arrested to the time that he had it dismissed, that 10%. Most importantly, and the key provision in the policy is subsection A, which says the RFD employee shall not receive reimbursement for any lost or reduced pay. So Monday morning comes around, and RFD issues a discipline notice letter. And that letter is also very important for today. That letter is enclosed with defendant's exhibits at Exhibit 5. It's issued by the Assistant Fire Chief, Kendall Hocutt, and it essentially tells Mr. Coates, we're aware of your DWI charge, and as a result, you'll be receiving a 10% salary reduction that's in effect as of November 9th, and he's also required to attend a substance abuse program through the city's REAP program. And then July 1st of 2021, the DWI charges were dismissed by the district attorney. At that time, Coates' salary was reinstated. And then a week later, Mr. Coates petitions the court, Carteret County, for an expungement, which the court grants. Then in August, Coates requests the city remove that discipline letter, that at exhibit number 5, from his personnel file, quote, pursuant to NC 160A 160A 8, subsection D, and City Policy 300-16. Because, as he says, that information is now inaccurate, misleading, and completely false. A week after that, Coates files another grievance seeking reimbursement of the 10% pay reduction. So let me talk a little bit about 160A, 168D in this personnel document. So what the general statute says is that essentially requires cities to enact procedures where an employee who objects to material in their personnel file on grounds that it's inaccurate or misleading can seek to have that material removed or have placed in the file a statement relating to that material. So in response to that statute, the city established that procedure, and that's Standard Procedure 300-16, and a copy of that is enclosed at Exhibit 8. Under subsection 5.4, which is on bait number 31 at Exhibit 8, it states that employee can request to remove certain material based on grounds that it's inaccurate or misleading, but they have to request that to the department head, at which point the department head reviews the request, and if the department head denies the request, the employee can either appeal to the city manager's office, or they can place in their personnel file that statement related to the disputed information. So on September 27th, petitioner meets with the fire chief to talk about this removal of his discipline letter. The fire chief determines that the letter is not misleading and it's not inaccurate, and he denied his request to remove that letter from his personnel file. But the fire chief also allowed petitioner to place in his file a statement noting that the DWI was dismissed and it was expunged. And a copy of that is enclosed at Exhibit 10. Most importantly, petitioner did not appeal that expungement, and I'll refer to this as the expungement request, to the city manager's office. Then about a week later, the fire department holds a hearing on his back pay grievance. The fire chief denies that request as well, citing section 5.33 of the DWI policy, which says that fire employees shall not receive any reimbursement for any lost or reduced pay. And then in December of 2021, the city manager upholds that decision, denying his request for back pay reimbursement. So, petitioner's request to the, or his appeal to the civil service. He's appealing both the denial of the back pay request, and also he appeals Chief Griffin's decision not to remove that discipline letter, which I'll refer to as expungement request. And his request for relief, he wants $19,343 plus related city contributions to his 457 account. He wants the commission to order the removal of all personnel records referencing the DWI charge. He wants payment on interest on all lost 457 contributions. And he wants attorney's fees. So the commission, and I'll talk about these, first I'm going to talk about the back pay grievance, and I'll talk about the expungement request. So the back pay grievance, the city does not, or the commission does not have subject matter jurisdiction to decide this. So as we know, the Raleigh Civil Service Act defines the scope of your authority. And it defines the subject matter that you're it defines your authority and defines the scope of the subject matter you're able to rule on and when you're sitting as an appeals board. And a copy of the Civil Service Act is attached to Exhibit 1. So under the Civil Service Act, the Commission is authorized to hear appeals regarding a violation of city policy that relate to one of the following: suspensions, layoff, removal, promotions, forfeiture of pay, or loss of time. Let me see if I can, well, I don't want to mess with it because I don't screw the whole thing up. No, that's fine. So, Commissioner, the petitioner has the burden to prove to you that you have authority over the subject matter that he's appealing. So, to invoke the Commission's jurisdiction, the hearing request must allege and demonstrate that an applicable city policy was violated with respect to one of those enumerated personnel disputes. And the Commission has dismissed grievances before for failing to allege a violation of city policy. That was in the Seth Simpson case, which is a copy of which is attached at Exhibit 17. As I mentioned, the grievance doesn't allege any violation of any applicable city policy, which is required to invoke your jurisdiction. It alleges various general complaints about the policy and why he doesn't like it, and why it's unfair to him, and why it shouldn't apply to him. But the Commission is not a general complaints board. The Commission is not here to hear just the general complaints and concerns that employees have over city policy, established written city policy. He also raises equity arguments and policy arguments, and why the Commission should reverse the city's decision in direct contradiction of the established fire department policy. Again, the Commission is not a court of equity. And although he's claiming unfairness, he hasn't alleged any discrimination claim. And so the Commission is without authority to decide the fairness of an established written policy. Sorry, let me get mine. And he also raises a contention that he calls, which I'll call his prejudice contention. It's number 2 in his request. Essentially says that the city's refusal to pay him back pay is prejudicial because he's not made whole. And in support of that, he references and he relies on a quote from Management Policy 100-16. And that quote says, in accordance with Standard Procedure 300-14, an employee under suspension for an alleged violation who is later proved not at fault must be reinstated without prejudice. Petitioner relies on that to say because he's not being paid after the expungement and after the DWI was dismissed, he's not being reinstated without prejudice. But that policy doesn't apply where there's a reduction in pay. That applies specifically when an employee is suspended from work. Mr. Coates was never suspended. Unlike other public safety departments in the city that have zero tolerance policies for employees who get DWIs, the fire department's was a 10% pay reduction. He was never suspended. Nothing in that policy prohibits the city departments from enacting departmental policies that dock an employee's pay for drunk driving. So next I'll talk about the expungement request. The Commission lacks jurisdiction for 2 main reasons. First, he didn't exhaust his administrative remedies. And second, disputes over the contents of one's personnel file is not one of the enumerated personnel actions that the Civil Service Act says the Commission has authority to decide on. So first, Coates did not exhaust his administrative remedies. The Civil Service Act states in Section 5, quote, the Commission shall have no jurisdiction to hear an appeal until all administrative remedies have been exhausted pursuant to the city's established grievance procedure. And 300-18, which is the city's established grievance procedure, says that appealing a grievance to the city manager's office is a prerequisite before an employee can appeal the issue to the Civil Service Commission. And the Commission has acknowledged this in the case Smith v. City of Raleigh, where it said that an appeal to the city manager is a required step in the city's grievance procedure, and the Commission dismissed that case on exhaustion grounds. So here, the request to remove his discipline letter was decided by the fire chief in September, and he never appealed that to the city manager. Because he didn't exhaust administrative remedies, the commission has no authority to hear that case. But even if he did exhaust those remedies, even if he did appeal to the city manager, the Civil Service Act still does not allow the commission to decide the issue. The commission is a board of limited jurisdiction that can hear appeals regarding a violation of city policy concerning one or more of those enumerated personnel actions: suspensions, layoff, removal, promotions, forfeiture of pay, or loss of time. Petitioner also lists a bunch of criminal statutes that he says, hey, these require the commission to remove all my DWI information from my personnel file, and also requires the commission to order the city to repay him back that 10% loss of pay. But these criminal statutes don't apply to the city of Raleigh, and they don't apply to the holdings of the city's personnel records, even if those criminal records are expunged. And no North Carolina court has ever held that those criminal statutes apply to a current employer's holdings of an employee's personnel records. And the statutes do not confer jurisdiction to the commission to order the removal of those records. Petitioner also argues that the July 7th, 2021 expungement court order that was entered by the district court in Carteret County also requires the city to, or the commission to vacate its administrative action against petitioner. But again, that order does not apply to the city, and a copy of that order is attached at exhibit number 6. By the very terms of that order, it expressly states that only the following agencies must expunge their records of the petitioner's DWI charge. It's a little hard to read because it's one of those, state court forms that have everything in tiny font. But as once you actually read the document, it says that only the SBI, DPS, DMV, court system, Carteret County Sheriff's Department, and Highway Patrol are to remove any references to the DWI. Again, absolutely no reference to the city of Raleigh. So in sum, the evidence supports and shows the petitioner has failed to carry his burden, proving that the commission has subject matter jurisdiction over this case. Therefore, the city asks that the commission dismiss petitioner's grievance appeal in its entirety. And I welcome any questions from the commission.
Are there questions for Mr. Seymour?
Thank you.
I do have one. I was
Sure.
just waiting. I just wanted to make sure I get an understanding. So the city is relying for and I'm talking about the back pay issue.
Yeah.
The city's relying on the fire department policy 1010.9.3. That's
right.
the policy that was followed, right?
That's right.
Is there any, and that's not a city policy, it's a departmental policy, is
That's
that
right.
right? Who approved the departmental policy?
It would have been the city manager.
So how does it work for these departmental policies? What happens if they conflict with the city policy? First question.
Well, that would be an issue for the commission to decide. There's been no allegation today that policy conflicts with any other city policy. But obviously, if there was a conflict, the city would do its best not to allow that policy to come in place. But if down the road there was a issue that was raised, then it would be the commission's, subject to other requirements, assuming that it was properly appealed to the commission, you could decide that issue.
And without presupposing what's being alleged here, I just mean if the city followed a departmental policy, but in doing so that violated a city policy, then that would be appropriately before the commission to argue that as a violation of the city policy?
I believe it would.
It would. And then the other question is, what happens if, what's the relationship between departmental policies and city policies in terms of, does the city policy have to authorize the types of actions that are put into a departmental policy? Do you have to be able to cite to where you're authorized to promulgate those rules under city policy? Or can it be like, well, there's no city policy that covers us, so we're writing our own policy?
You're thinking like Congress and things. I would say that so long as it doesn't conflict, necessarily authorizing a policy. So the charter gives the city manager broad discretion in policy making and the HR department policy making, and through those administrative processes, they work with the department heads to formulate these policies, which assuming that there is no conflict, that they can present that to the commission. Excuse me.
And then I really appreciate all these answers. And then the last thing is just still on the back pay issue. Is it an undisputed fact in your view that he was charged with DWI as a legal matter?
Yes. Yes, it's admitted in the request for hearing.
Gotcha. What I'm trying to get my head around is the expungement basically says this never happened, even though as like a sort of fact about the world, it did happen. That's why we're here.
That's right. And that was the purpose behind Chief Griffin's non-removal of that disciplinary action letter, because the letter says you were charged with a DWI. That's a fact. That happened. That happened in the past. What happens after that? So the expungement statutes, the purpose of those statutes is so that an employee or someone won't be criminally responsible for perjury or making false statements. If someone asks them, such as a prospective employer, have you ever been charged with a crime? They can say, no, I haven't, because those charges were expunged.
I mean, it would also be so that they're not prejudiced by charges that were dismissed and found, under our legal system to be unfounded because they were dismissed, right? Like
charges that were dismissed, right?
Because they wouldn't have to perjure themselves. They could just say, yeah, I was charged with a DWI.
Sorry, could you slow down
Sure.
just a little bit?
Sure. They could just say, yes, I was charged with a DWI, but that's, I assume the policy is that would be seen as prejudicial in a job interview. So it's not just so they don't perjure themselves, it's so they're not prejudiced by the fact of the charge. Is that fair?
I would say, as to prospective employers, yes.
And then this is just one last question, then I promise I'll stop.
You're fine.
I will probably stop. What if the expungement order applied to the city expressly? It said the city of Raleigh shall expunge its records. Would the city be able to refuse to restore the lost back pay in that situation where a court order says you'll disregard these charges?
I would say no, because that order specifically says references to the DWI. The order does not say anything about lost wages whatsoever. And if it expressly said the city of Raleigh, then the city would comply with any lawful order.
Thank you very much.
Thank you.
I've got a couple questions,
Sure.
And you may not know the answers to these, but I think there's something to think about. Is what's the city's policy if Captain Coates' identity was stolen and it came back and it appeared as though he was charged with a DWI, and then his pay was immediately docked, and then 6 months later they realized that it was a matter of identity theft. In that case, would his forfeiture of pay be reinstated?
I don't know the answer to that.
Okay. And the same thing for, if the officer was complete malfeasance and was charged with a crime in connection with the DWI, and it later came out that the officer had ulterior motives and Captain Coates was not under suspicion of DWI. It was malfeasance by the police officer. What would be the city's policy on that?
Well, I think you would have to look at what the policy actually says, which is if you're charged with it. Now, the policy, the 300 dash, I think it's 300 dash, 100 dash. Where are you? 16. It acknowledges, hey, look, charges can last a long time, and we're not going to know the answer or the outcome of any of these charges. But in situations like that, just the fact of the charge itself raises issues of, it says moral turpitude and possibility of the employee not being able to perform their duties.
Potentially.
That's right.
Because because if Captain Coates was sitting, under oath right here, right now, and we were to ask him, "Have you ever been charged with a DWI?" What would his response be?
I don't know.
Yeah, it would be you said earlier the purpose of the expungement order is so that that he's never been charged with a crime with prospective crime.
The purpose of the expungement order is for any record of it from the enumerated agencies would be removed.
Sure, but if you were to sit before a prospective employer and been asked if you've ever been charged with a crime, you could truthfully answer no.
That's right. Well, I wouldn't say truthfully, but he could answer no without subject to any possible criminal sanctions. And that's prospective employers. The expungement statutes don't apply to current employers.
Sure, but the city policy says somebody who's been charged with a DWI, and the question is has Captain Coates been charged with a DWI?
I don't agree that that's the question today. I
Okay.
think the question is whether or not he should be reimbursed the back pay. I think that
the charge is the charge is the first thing that has to be decided, because then if he was never charged with a DWI, then the city never should have deducted his pay. So it's a logical conclusion. So the issue at hand is, has he ever been charged with a DWI? Because it would be the same thing of a clerical error, that if the city had a clerical error and they noted that Captain Coates had been charged with a DWI, docked his pay, he gets his paycheck, and he's like, what? And he goes downtown, and they're like, oh, this is a clerical. Sorry, I talk really fast. Then he goes down to HR and says, I was wrongly. Then they would say, oh, you're right. You weren't charged with a DWI. That was a clerical error, and so it would be logical. I think everybody in this room would agree that he would be due back pay.
Well, I think you would have to look at what happened back in 2019, whenever he was charged with the DWI, and whenever he did tell his supervisors. There's no evidence that there was something like that ever happened.
Sure, but that's the purpose of an expungement order, is it reaches into the past and erases things.
I respectfully disagree with that.
Okay.
But
I don't have any more questions.
Thank you. Mr. McCormick?
Thank you, Madam Chairman. Mr. Seymour, the form, Exhibit 6 in your book, the order of expunction,
yes,
the
Commissioner.
form clearly states, and I believe you alluded to this in your presentation, that it only applies to certain agencies. And there are 3 blocks on the form: the arresting agency, the other agency, and then name and address of other agencies. And that was left blank. Now, had Mr. Coates, Captain Coates, had he put City of Raleigh in that 3rd block, would this be a different situation?
I think it would. I think it would, because then we'd have a court order telling the city to remove certain records from his policy. But that's something he could have asked back in 2021, but he didn't. And although the statutes that underlie expungements don't talk about current employers, I think that the city would have to comply with any lawful order, so long as it doesn't conflict with other statutes and constitutional guarantees. But yeah, it's a little, so the order's tough to read, but you can also look down at page 2 at the bottom. It says note to clerk, and it also lists the SBI, the DPS, the DMV, because as the agencies that are to have this removed. Sorry.
Anything further, Mr. McCormick?
No, ma'am. Thank you.
Any other questions for Mr. Seymour?
Thank you, Commissioner.
Thank you, Mr. Seymour. Mr. Crawford?
I don't have a presentation. Do I need to go to the
Yeah, if
lectern?
you don't mind, just so that you'll be the same level of microphone and everything else, and the court reporter can hear you and see you.
All right. Thank you again. My name is Bob Crawford, Wake County Bar, and represent Captain Coates. Just a little more background information about Captain Coates. Been with the city for now over 35 years. He's been a captain for over 22 years. He's currently and has been for a while in the Special Operations Command, the HAZMAT unit. So he's obviously a dedicated employee, loves his job. But the reason we're here, or part of the reason we're here, is because his pay was docked, and it ended up being for 20 months, mostly because of the COVID delays that delayed everything in the court system. Therefore, the 10% reduction ended up being about $20,000. And at his point in his career at 35 plus years, the effect of that going out into retirement is, by his estimate, more like $120,000 over the course of his retirement if this 10% reduction remains in place. So that's sort of why this is such an issue for him. It's not just $20,000, it's $120,000 over the course of his future retirement whenever he retires. So that's why this is important to him and worth coming here and worth trying to figure out all the nuances of this issue. As you've seen, there are quite a few trying to navigate this. A couple of other points I want to make, and I guess to focus our argument on the jurisdictional part, which Mr. Seymour's pointed out, you don't have jurisdiction. You're not a policy-making board. It has to involve a violation of a policy. And so to refine that further, I would say that this does involve the violation of a city policy, which is you can't reduce an employee's pay for no reason. There's got to be a reason. And here, there is no reason, because the reason that existed no longer exists because of the court order expunging all records of it, which have all been expunged from the SBI. So if you go look at the SBI record, there's no record of it. If you look at the DMV records, there's no record of it. There's not even a record of the civil revocation, and was not even at the time a week after the incident in Carteret County. The only record that now apparently exists is in his personnel file, because the chief declined or refused to remove that from his personnel file, allowing Captain Coates instead to put a statement in addition to his personnel file. So that's the only place this record of this even exists any further, is in the city records. I would also point out that in trying to navigate through this, Captain Coates went through the appeals procedure up through his chain of command to the city manager's office, and the assistant city manager tasked with this in her letter upholding the matter said that you may appeal to the Civil Service Commission. So that's what he did. And then, of course, we're faced now with the motion to dismiss on jurisdictional grounds. Let me point to a couple other documents in the city's exhibit number 4, which is the arrest warrant. And by the way, this is an arrest for driving while impaired. It doesn't say anything about drunk driving. It's driving while impaired. On the 3rd page there, you'll see that the judge ordered, it looks like on November 7th, that the revocation of the petitioner's license be rescinded. And let me point out again sort of why this fire department policy really makes no sense, particularly in this case, because Captain Coates, as part of his job as a captain for 22 years, has a driver, an assistant driver. He doesn't operate a city vehicle. He doesn't operate any fire apparatus. He's a supervisor and a commander and directing others. He continued in his job for 20 months while this was pending due to COVID in the court system, with absolutely no change in his job duties day to day at all. There was no, he was not required to drive, not required to have a license, doesn't drive as part of his job. So there's nothing changed about his job while this was pending. And again, it's as if it never happened and did not exist, and that there was no civil revocation, there was no arrest, there was no charge, there was no DWI. I've got some additional exhibits that I will hand out here. If you can just pass them down if that's all right. All right, so exhibit number 6. So if you go to the City of Raleigh website and look for the
Commissioner, at this point, I would object to any additional exhibits. These are brand new, and I don't know what they are. So if I could have a moment to review them at least.
I'll give you a moment.
Oh, the bylaws?
Yeah.
There's more on subsequent pages.
it's 6, 7, and 8.
Oh, then that's fine. No objection.
No objection?
All right. All right, so Exhibit 6, if you go to the city website, look for the civil service rules, you'll see Rule .0201, and it states, "The commission shall hear all appeals of employees regarding violation of city policy relating to suspensions, layoffs, removals, demotions, promotions, forfeiture of pay or loss of time." So in the rule that's on the city website for the Civil Service Commission rules, it applies to demotions. And if you look at the Exhibit 7, which is the personnel action form that was issued to Captain Coates on November 9th, 9 days after the alleged incident, it says action is demotion, and below on Section 2 it says 10% reduction in his pay. So I would contend that the Civil Service Commission rules state that you can hear matters involving a demotion, involving a city policy, violation of a city policy, that Captain Coates was demoted in pay. He was not demoted in position, but demoted in pay. And therefore, that gives you the jurisdiction. Now, it would appear there is a conflict between your rule and the statute authorizing it, because the statute apparently does not include demotions in there, but your rule that's been here since 1981 does include demotions. So if any city employee goes and looks, what are my rights? I look at the Civil Service Commission rules. It says demotion. I've been demoted in pay. I should be able to appeal that ultimately to the commission. And that's what Captain Coates has tried to do, and we're here today. Exhibit 8 is his DMV driving record from November 12th, 2019, 12 days after the alleged incident. And you'll see that even 12 days later, there's no evidence of the charge or any civil revocation. So it's of his driving privilege. Now, Mr. Seymour's pointed out that we've got a second argument or issue involving whether or not he's appealed his the denial of the removal of the information from his personnel file, as opposed to just allowing him to place a statement in his file about it. But but it would appear, as he said, even if you had appealed that, Civil Service Commission doesn't have jurisdiction over that matter, so it would have ended with the city manager's office. So I'm trying to think through this. If the city manager had said, okay, we'll remove that from your personnel file, would they have reinstated then his not reinstated, but reimbursed him for the loss of pay, the 20 months loss of pay? So I would contend that you have jurisdiction over that issue as well, to hear the appeal of why his pay should be restored, the 20 months worth of pay, which is about $20,000. Mr. Rubin has asked good questions about why this fire department policy exists. Does it conflict with any city policy? I didn't see any policy similar to that relates to, for example, police officers. So why does the fire department have a policy different from police officers if a police officer is charged with DWI? They're not, from anything I could find, they're not subject to a 10% reduction in pay. So it does seem this is just a fire department policy. Again, I understand you're not a policy-making body, but there's grounds here for the commission to hear a violation of policy, referring back to what I said at the beginning. The violation is you've got to have grounds to demote someone in pay or to reduce their pay, and in this case, there is no grounds for that. That is a violation of the city policy, and that's why I would contend you have jurisdiction to hear his appeal to restore that money that has really a long-term effect on his future retirement. We'll call it an aside, as I put in the appeal to begin with. Mr. Coates, at his rate of pay, the city's actually losing money at this point, because if he were to retire, they could replace him with a captain at a much lower level of pay than he's making now. So financially, it doesn't make any sense. But I understand that's an aside that doesn't really go to your jurisdictional question. But I would contend, again, you do have jurisdiction because there's been a violation of city policy, which is you cannot reduce someone's pay without cause, and here there is no cause now to do that. So try to answer any questions you might have.
Commissioners have any question for Mr. Crawford?
I don't always have to go first, but I don't mind.
Go ahead, Phil.
All right, let's do the city record expungement claim first. There's no dispute that it wasn't appealed. Is that correct? That the request was made to expunge the records, fire department said no, and your client didn't appeal that anywhere else.
Did not go up to the next step, the city manager's office, correct? That's
and so
correct.
I guess I'm having trouble, we require exhaustion. It has to be exhausted all the way through the process before we can hear a claim. So if my inclination is we should grant the motion to dismiss as to that because it's just not exhausted and we've dismissed claims plenty of times, am I misapprehending it? How?
No, you're not. You're not misapprehending it, and I suppose that was a strategic or decision that we've tried to make at the time of what to appeal, what could be appealed, and it could only be appealed to the city manager's office in any event, and that was as far as it could go. It would look like based on what's appealable.
And not criticizing any decision making that went on. I just mean in terms of our jurisdiction, if it doesn't go all the way through the process, we can't hear it. On the back pay claim, it would be really helpful to me to think through this if you could identify what policy, as opposed to just sort of the city can't just take your money. in leaving out the possibility that there might be some claims out there in some future case where there's not a written policy that's violated, but here it would be really helpful if you could point to a provision and say the city violated X policy by doing Y thing. Can you help me with that, because that would make this clearer for me?
I wish I could point to a numbered policy in the handbook. I don't have that before me at this time, that if it even exists in there, that states that. But the only policy here is a fire department policy, not a city policy, and this apparently unique to the fire department and not the city.
And if we were to go to an evidentiary hearing on this, would it be a stipulated fact that your client was charged with DWI? Would you stipulate to that fact or not?
Well, that's an interesting question, again, because of the statute that says by the judge's expunction order, it's as if it never happened. But yeah, in reality, yes, it did happen, but by law, it didn't.
So that's what I'm trying to figure out. Let me just back up and be clear with my question. Under 1010.9.3, the whole set of rules about when you have an impaired driving offense, are you alleging that that was not followed correctly here, that was improperly applied to your client?
Which
It's the specific provision that says, starting at 5.1, an RFD employee who receives a citation or otherwise is charged with an impaired driving offense or et cetera shall, and then 5.1.4, receive a 10% reduction in salary which shall remain in effect until the disposition of the case. And then it later says in 5.3.3a, the RFD employee shall not receive reimbursement for any lost pay when acquitted or charges dismissed.
Right.
So I'm just, for absolute clarity, are you alleging any violation of that?
No, and I would point out that, Captain Coates reported himself, promptly and immediately that this had happened. So the fire department did follow its procedure to reduce his pay by 10%. So we're not alleging a violation of that, but after the fact, we're saying that it ended up being a violation of policy because of the subsequent expungement of the whole matter.
Understood. Thank you very much.
Any other questions?
Am I allowed to speak to that?
Mr. Crawford, I don't think so, Captain. I think we're going to restrict our comments to the lawyers at this time. Thank you. Any other questions for Mr. Crawford?
Okay.
Mr. Crawford, I do have one question with regard to the fire department policy. I think the city's Exhibit 2. Do you have an argument or contention about the policy says that it's departmental operating instructions, and I think the city has taken the position that it was approved by the city manager. Do you contend that that means that it is not a city policy at this point? And if so, help me understand that.
Well, it's a fire departmental operating instruction. That's what it says. City of Raleigh, administrative directive. Well, presumably approved by the city manager. We don't. But again, I would say that it is unique to the fire department, and which is not unique in terms of other city employees who may or may not be required to have a city driving permit, which is the purpose here. So you've got a policy that presumably approved, but is creates a situation here that when the expungement has been issued, should now be vacated, as is any other record of the charge.
And that's based, your argument is based on the order that was entered with regard to the agencies that were to expunge the record?
Yes. Now, realizing that the Roger Crow, the lawyer in Carteret County who represented him on the DWI and on the expungement, as Mr. McCormick pointed out, it only lists those state agencies and not the city of Raleigh or any. But the statute says, get that out. 15A 145.5 F, which is the expungement of certain misdemeanors. It says any other applicable state or local government agency shall expunge from its records entries made as a result of the conviction or convictions expunged under this section. And the statute, the section F goes on to say the agency shall also vacate any administrative actions taken against a person whose record is expunged under this section as a result of the charges or convictions expunged. Would we be in a different situation had the judge ordered the city of Raleigh, or if the judge entered an amended expunction order, which I suppose is possible, an amended order ordering the city of Raleigh to expunge the records? Would that then cause the fire department to restore the back pay? Suppose if those are hoops we have to jump through. It seems like that should not be necessary, that the statute says it applies to local government agencies. That would be the city of Raleigh.
Okay, thank you. Any other questions at this time?
Yeah, I'll ask you a couple of the same questions. So if Captain Coates was under oath here with the commission and he was asked if he's ever been charged with a DWI, what would be your recommendation to him on how to answer that under oath?
Well, I know whether he takes my advice or not, he's going to answer
Sure.
no. He's going to answer no.
Sure. Okay. And if he were being hired by another governmental agency and the questionnaire or any other job and asked if he's ever been charged with a DWI, what would be your recommendation on him on how to answer that?
Certainly no, because that's clearly the purpose of the law, and is to, as if it never happened.
Okay. Thank you.
Anything else before, Mr. Seymour, do you want to respond briefly?
Just two quick points. Opposing counsel raised why RPD doesn't have a policy like this. It's because RPD has a zero tolerance policy. If you're charged with a DWI, you're fired. The fire department just docks your pay 10%. And also, reading the actual statute for expungement, subsection A talks about the purpose. The purpose of this section is to clear the public record of any entry of any arrest, criminal charge, or criminal conviction that has been expunged. Personnel records are not public records. That's all I have to say.
Well, parts of personnel records are public in the statute. So certain parts are confidential, certain parts are open to the public. And I think it includes reasons for termination or demotion. I think is one of the public parts or non-confidential parts of a employee.
The statute says that what is public is salary, and that would be something to disclose. But absent an authorization from Mr. Coates saying the city can release that single letter about his demotion or his forfeiture of pay, it would not be released.
All right. Thank you. Now I open the floor for commissioners to make any discussion or have any, express your views about this motion? We've heard both from the city and from Mr. Crawford back and forth. Do the commissioners want to discuss this matter before we vote?
Yeah, I mean, I think the way I'm viewing this is that the purpose of the expungement order. I mean, I think if the expungement order was not in place, then we wouldn't be here, right? Because no violation of city policy could clearly be argued that it was violated. But the purpose of the expungement order is that it is to reach in the past and change things, because the Division of Motor Vehicles, the State Bureau of Investigation, all these places had a record of this incident, and now they do not. And that's by fact of the expungement order. And so the expungement order does reach into the past and change things as though it never happened. And it's my understanding that if Captain Coates were to apply for another position with the city of Raleigh, there would be no record. The places that the city of Raleigh would look, there would be no record of this charge. And so that is where I see this contention. And it clearly, we clearly have jurisdiction, because on the discipline form for the fire department, it does say demotion, and that is clearly within our jurisdictional bounds. And so I think the way I see it is that the expungement order is supplemental to the demotion, not because we wouldn't have jurisdiction over. I mean, how would he appeal the expungement order to the city manager? That's not something I think we would have subject matter jurisdiction over of what's happening in his personnel records and stuff like that. I mean, so that's kind of the way I see this. And so I think I have a lot more questions that I would like answered to figure out the resolution to this case.
Is there other discussion?
This is another one where a lot of the argument that we heard was about the policy being bad, and that is outside our jurisdiction for sure. Things about it being inequitable or it being a poor decision, we're sitting at the city council's table, but we're not the city council. Where I am on the fence is that this question of whether he was charged with a DWI or not. As a factual matter, obviously he was, and no one's arguing it. As a legal matter, that is less clear, and I'm still, after argument, not entirely clear on that question, which to me means if, as a legal matter, he wasn't, and someone was in here, we were having a evidentiary hearing, and the city had to prove he was in fact charged, I'm not convinced the city could prove that, because it could not introduce legally the conviction records to prove that fact. They've been expunged. So in that sense, I thought the arguments would be a little different, but taking the arguments that were made by council, there's not a city policy that is alleged to be violated. And in that sense, that has me leaning towards thinking that we should grant the motion to dismiss, because there's not a city policy being alleged. But I'm on the fence on that, and would be interested in others' thoughts before we make a decision. And then on the city record expungement piece, I think it's just a clear-cut non-exhaustion.
Other viewpoints?
I think I just want to echo what Mr. Rubin just said. I mean, this is a flawed policy in my view, but I don't think we have jurisdiction to say, change any of this. We're not the city council, as you said. But there is a lot of gray area in terms of his expungement, whether he was charged or not to begin with. I think, like Mr. Rubin said, I'm definitely on the fence about this, but I am leaning towards granting council's motion.
You mean the city's motion?
Oh, the city's motion, yeah.
Okay, all right. Any other discussion, Mr. McCormick?
No discussion, but I'll just go ahead and move that the commission grant the motion to dismiss.
Can I speak up here? Sure. Since one of the issues, is there another city policy that I could allege was violated? If you could hold your decision open to see if we can identify such a policy that you could then consider or reconsider the motion at that point, if you would consider holding this open. for that
The city
purpose.
would vehemently object to that. The commission's, or the statute specifically says the commission can only consider those matters raised in the request for hearing. Nothing was raised in the request for hearing that alleges a violation of city policy. So plaintiff's counsel can present nothing after this that you could consider that was outside the scope of the hearing request.
Well, I'm going to deny the motion to hold the hearing open on that issue, just because I agree with the city on the question of, we have a request for hearing, this is the day for the hearing, and I think we have the matter before us. Now, Mr. McCormick, you had something that you were saying.
No, I was just saying I would move that we grant the motion to dismiss.
On both grounds?
Yes.
Both-
I'm sorry,
On both grounds.
both grounds.
Uh-huh.
May I speak to the motion?
You may.
Before we vote? The only thing that I would add is I would vote on the city record expungement piece only on non-exhaustion. There was another claim made, I believe, about, oh, maybe that's in the other case, actually. I think there were, about our jurisdiction. There was a second point about that, about jurisdiction. I wouldn't answer that question right now. I think for non-exhaustion, it's very straightforward. So I would just state for the record that my vote in favor as to the city record expungement would be on non-exhaustion and not the entire argument the city made.
All right, so we can, I guess, vote for, let me ask you, and counsel, Mr. Seymour, is your motion, do you recommend that the city commission here vote separately on both grounds, or? How are you
I would defer to the commission. I think the city's request was to dismiss the request in its entirety.
Okay.
I divided up the arguments for purposes of today, but I think for
All right,
your
so
purposes
for
in its
clarity
entirety.
purposes, let's vote now on the expunction aspect of the motion to dismiss. Mr. McCormick, could you, is it possible for you to amend your motion to talk first about that, and then we'll take up
Well,
the other?
I can just withdraw that motion, and somebody else can make a different motion.
I'll move to dismiss the claim to grant the city's motion to dismiss the claim regarding expunction of city records for non-exhaustion.
All right. All commissioners in favor of the motion to dismiss the expunction aspect of the motion to dismiss, or the petitioner's appeal, please say aye.
Aye.
Aye. And any commissioners opposed?
Aye. Or nay.
All right. Now let's move to the second aspect of the motion to dismiss, which is the aspect of the forfeiture of pay, the city policy regarding the forfeiture of pay or demotion. Is there a motion on that regard from the commissioners?
Well, again, I would move that we the board grant that part of the motion as well.
Any further discussion on that motion? All right, all commissioners in favor of Mr. McCormick's motion to grant the motion to dismiss on that aspect of the hearing, please say aye.
Aye.
Aye. Any commissioners opposed?
Me.
The motion to dismiss is granted.
Thank you, commission members.
All right, we've been going about an hour and a little bit. Let's take about a 10-minute break, and then we will take up the next matter. So if the commissioners and the parties can be back here at about 10:20. two matters here with regard to the Patrick Lands versus City of Raleigh appeal, and I want to just explain part of this, which is there's a motion to dismiss by the city, and there's also a motion to obtain subpoenas from counsel for Mr. Lands. And I want to just explain as a matter of just protocol, ordinarily the question of subpoenas, it may or may not be agreed upon, and in the past, in my experience, the chairman or the chairperson has had the authority to issue the subpoenas. But my understanding is that when there's a objection to the issuance of the subpoenas, that it's appropriate and has been the practice in the past for the entire commission to hear that question. And so that's where we are today. The petitioners requested subpoenas, the city objects, and so I'm going to let the whole commission weigh in on that. I decided also, just as a matter of efficiency, to go ahead and allow the city to argue its motion to dismiss, and to the extent there is any narrowing of the issues, that may or may not inform the commission as to the motion for subpoenas. So I'm going to let Ms. Tejada, if you want to go first with regard to your motion to dismiss, and then we'll hear you want to introduce yourself?
Yeah, Valerie Bateman, and I would like to tell everybody that I am hearing impaired. So if you could speak up, that would be great. And I apologize if I have to ask you to repeat yourself.
Thank you, Ms. Bateman. And did you hear what I just said? Do you want me to repeat that?
Well, I heard that we're going to hear the motion first,
Okay.
and then the subpoena motion.
That's exactly right. And I explained why I believe that the entire commission should hear the issue of the subpoenas.
And I got most of that.
Okay. All right, excellent.
Thank you for asking.
All right. So I'll now turn to the city. Ms. Tejada, do you want to present the city's argument on the motion to dismiss?
Thank you, Your Honor. Good morning. May it please the Commission, my name is Alice Tejada. I'm a Senior Associate City Attorney with the City of Raleigh, and I will also need to go to the lectern if that's all right.
Yes. Thank you.
These are not built for the vertically challenged. So the city filed a partial motion to dismiss. This is not a motion to dismiss the entire appeal. And it's the city's understanding that the petitioner is essentially arguing that the city unlawfully terminated him and that it used its policies as a pretext for unlawful discrimination and retaliation in the termination. And so the very discrete question is, does the commission have the jurisdiction to essentially hear an FMLA claim? As has already been articulated earlier today, the commission, as you all know, has limited jurisdiction. It has the authority given to it by the Raleigh Civil Service Act. And if you do not have a copy of the act, I have copies with me that I can provide to you.
Ms. Tejada, we have the act in our binders.
Oh, okay, thank you. And so according to Section 5 of the 1989 Sessions Law, Chapter 817, the commission has the jurisdiction to hear appeals of employees regarding violations of city policy relating to suspensions, layoff, removal, promotions, forfeiture of pay, or loss of time. Now, City Standard Operating Procedure 300-14 is the disciplinary policy. It requires that decision be made based on sound and considered judgment. And again, as I said before, Mr. Lands argues that his termination was pretext for illegal discrimination and retaliation against him for taking FMLA leave as well as sick leave. He has filed an FMLA retaliation claim in the Eastern District of North Carolina of the U.S. District Court in federal court under the federal statute of the Family Medical Leave Act. And so it's not as if Mr. Lands is without options to argue his allegations and present his claim to a court of law. It's just that this particular jurisdiction, this particular quasi-judicial commission does not have the authority to hear that FMLA claim. The Civil Service Act does have a definition of discrimination and does prohibit discrimination in the act. However, that does not include family medical leave. It only includes discrimination limited as to race, creed, color, because of political or labor affiliations, or because of sex or marital status. So in looking at what particular policy could have been violated by the city, or what the allegation could potentially be, we obviously look to SOP 300-20, which is the family medical leave policy. And this is the old policy. And when Mr. Lands took leave, he was covered under this old policy. That has been superseded, but that was not until 2021. So again, the commission has jurisdiction to hear allegations that the city has violated 300-20. But the family medical leave policy has a set of established procedures that the city is required to follow in administering its family medical leave. Potentially, if the petitioner believes that the city didn't follow those sets of procedures, then he could establish potentially some sort of city policy violation in violation of the Raleigh Civil Service Act, which certainly the commission would have jurisdiction to hear. However, at least from the materials I've received, there has been no such allegation. And in fact, Mr. Lands received all of his FMLA leave to which he was entitled by law. He was provided with 12 weeks of leave. And in addition to that, he was allowed to be on sick leave, paid sick leave, for an additional year. So in terms of whether the city has violated SOP 300-20, it does not appear that that allegation is being made. And so the commission doesn't have jurisdiction to hear that his termination was unjustified based on a violation of, the commission does have jurisdiction to hear that his termination was unjustified based on a violation of other policies. The policies that the appeal requests seem to focus on are the family medical leave issue and the secondary employment policy that RPD has established. Aside from that, there are other policy violations that the petitioner has alleged, but for many of these, it's unclear what specifically about these policies the city has potentially violated. So the city doesn't really have much notice about that. I think there's an argument that has been made that these policies have been violated because they were used as pretext to unlawfully discriminate and retaliate against Mr. Lands. But again, that would be sort of, I guess, evidence of an FMLA claim, not city policy violations in themselves. There was an argument about the petitioner having a property interest. I'm not really sure how that relates to the motion to dismiss claim that the city has filed for the FMLA portion. However, I can address that, and so it's well established by the North Carolina Supreme Court under Souls versus the City of Raleigh that City of Raleigh employees do not have a constitutionally protected property interest in employment. There is no just cause requirement in the Civil Service Act, and it's my understanding from the petitioner's response to the city's motion that there's an argument that the Raleigh Civil Service Act itself provides for just cause terminations only. The city obviously disagrees with that. The Court of Appeals has addressed this matter with the City of Asheville's Civil Service Act, and it basically said that unless there's language that specifically says that the act requires just cause terminations, then there's nothing in those acts to indicate that the legislature intended to give the City of Raleigh employees property rights. And there just isn't a just cause definition or term in the act itself. Now, what the Civil Service Act does present is the burden. It tells you what the burden is for these types of decisions. And the burden is on the employee to show that the city's decision was justified. If there were a just cause standard under the Raleigh Civil Service Act, then presumably that burden would be on the city, not on the employee. Additionally, City of Raleigh Policy 300-1A defines just cause as a legally sufficient reason. And also, whether the act provides the city's employees with a constitutionally protected property interest is outside the commission's jurisdiction. The Supreme Court, the North Carolina Supreme Court has said, and the Court of Appeals have said, that it's settled law that administrative bodies are quasi-judicial bodies, and that they are not empowered with the authority to decide constitutional matters. For those reasons, the city requests the dismissal of any portion of the petitioner's claim that is alleging an FMLA retaliation claim for lack of jurisdiction. If the commission has any questions, I can try to answer them.
Do the commissioners have any questions for Ms. Tejada? All right, hearing none. Ms. Bateman, do you want to respond?
Yes, do you?
If you don't mind, please.
I do not mind. Good morning, Commissioners.
Still morning.
And
yes.
Chair Klein. Thank you for this opportunity to be here in front of you today on behalf of Mr. Lands. I just have a few points I would like to make in response to some of the points that Ms. Tejada made. She noted first that it was a partial motion to dismiss, and I believe that that focus of that motion to dismiss is on what she considers to be the FMLA claim. And I would submit to you that And let me just say this, it is true that Mr. Lands is pursuing a FMLA claim per se, on its face, a flat-out FMLA claim in federal court. And the federal court has denied the city's motion to dismiss and found that the complaint is plausible. And so we're proceeding on that. So I don't think it matters so much whether the city specifically considers whether Mr. Lands was discriminated against because he took FMLA leave. The core issue is whether his termination was justifiable. And I submit to you that that is tantamount to saying the city had to have just cause. We don't have to get into the constitutional property interest arguments. I would just say to you that I believe the Souls case does stand for the proposition that the burden can properly be placed on the employee in the Civil Service Commission proceedings, but I would also suggest to you that the Souls case decision that that employee had no property interest was based on an argument made to them that the personnel policies created the property interest. And as Ms. Tejeda said, we are not arguing that the personnel properties create a property interest. We're arguing that the law itself creates that property interest by saying that employees that are terminated without justifiable cause have a property interest in their employment. If they can only be terminated for justifiable cause, then that's the same thing as just cause, which is comparable to 126-35. I think Souls is still good law, and well, Souls is period good law. I'm just saying I think the Souls holding as to property interest should be carefully considered when looking to it as support for the proposition that city employees have no property interest. But again, I don't think that that's any issue that this commission needs to reach today. As Ms. Tejeda said, it's a limited motion to dismiss, and if you choose not to hear anything about the FMLA, then I don't think that affects my client's interest. As if you don't dismiss, well, even if you grant the dismissal, we'll get to the subpoena issue, and in the subpoena issue, I can explain more fully why we believe there was no justifiable cause for his termination and why we need these records to show you that. So I don't have anything else on this motion to dismiss, unless you have questions, of course.
Are there questions for Ms. Bateman?
Thank you. I guess what I'm trying to figure out is whether there is really a dispute here about the existence of a standalone FMLA claim. Do you say that there is or is not a standalone FMLA claim present in this action?
I don't think there's a standalone FMLA claim in the Civil Service action because I think it's part and parcel of the question of whether there's justifiable cause for Mr. Land's termination. I think that's the underlying issue. I think that also includes discrimination. Now, Ms. Tejeda talked about the limited nature of the discrimination that can be heard by the Civil Service Commission based on the language in the act. I find it hard to believe, but I could be wrong, of course, it's happened many times, that this commission would tell somebody who, for example, came before them and said, listen, I was terminated because I had a disability. Disability is not listed in your act. Neither are other protected grounds, such as transgender status or sexual preference. Those things are not in your statute either, and I find it hard to believe that this commission would say it's okay to discriminate on the basis of those grounds. Maybe you would, based on that limited language, but I think when it says discrimination, discrimination should be read in the context of what current state and federal law consider to be illegal. It would be, the whole point of the Civil Service Commission is to nail down these potentially risky decisions so that the city doesn't get whacked with a bunch of attorney's fees and back pay. And so if this commission is to do its job, it would look at whether the claim has some merit even outside of some narrow, parameters that could be argued to exist. So that's what I would say about discrimination. I think even discrimination comes up under the no justifiable cause rubric. If there was discrimination, there was no justifiable cause. If he was terminated, treated more harshly than other people simply because he had taken FMLA, that's no justifiable cause. I think the issue is no justifiable cause, and I think that can go lots of different ways.
So, and thank you for that. In checking my understanding, and this isn't my area of law, so let me check my understanding. There's not really a basis in law for you discriminated against me because I was on FMLA. That's an FMLA retaliation claim under FMLA that you would make in federal court typically. But you could make a claim that you discriminated against me because I'm disabled, which is why I was on FMLA, in which case the discrimination case would spend a lot of time talking about FMLA as a factual matter and the leave and stuff. Am I way off, a little off?
No. I think that's a very good question. Here's what I would say to that. Retaliation and discrimination are different sides of the same coin. In fact, discrimination is the overriding term that we use, and retaliation is really understood as just to be another form of discrimination. In the FMLA world, you have interference claims, right? And then you have retaliation claims. But they're all, like, if they didn't let him take it, and as the city has often argued, and as we concede completely, he was allowed to take ample FMLA and sick leave. There's no interference with that claim. But did they come back then after he'd been at work for 6 months and treat him differently and more harshly than they would have somebody else because he took FMLA? You can call that you can call that discrimination, you can call it retaliation, but it's the same thing. It amounts to a lack of justifiable cause. If they treated him differently because of that, then they didn't have just cause to terminate him. So I don't know if I answered your question or not. I tried.
No, I think that's very helpful, and I'll just lay out where my head is at. Is that if we all agree there's no standalone FMLA retaliation claim in this case, then I guess I don't see the harm in the commission granting a very limited motion to dismiss that, since if you're not taking the position there is one, and if we're clear that as the case proceeds, we recognize that the parties may still have debate about FMLA and its role in the factual presentation and the other claims that you claim are under city policy. So without prejudice to any of that, if there's no dispute over the lack of a standalone FMLA retaliation claim, then great. I like it when there's no dispute. We can resolve that, right? And it's important, and the reason it's important to me is twofold. One, it goes to our jurisdiction because we don't typically hear federal claims or constitutional claims or even state law claims. But the second piece is if that is being actively litigated in federal court, it's extra inappropriate for us to be deciding that matter here, because then you could have conflicting decisions. And obviously I'm well aware of who wins in that circumstance. But I just don't think we'd want to be in that world. But also I don't want to prejudice you by a too broad a ruling that basically says we can't hear anything about the FMLA, because I don't think as a factual matter that would be correct.
I cannot disagree with anything you just said.
Okay, thank you.
Any other questions for Ms. Bateman at this time? Ms. Tejada, do you have any kind of response?
No, Your Honor.
All right, now is the time for commissioners to have any discussion about this limited motion to dismiss, partial motion to dismiss.
I didn't get any of that. I'm sorry.
Okay, now I'm inviting the commissioners to discuss the motion.
Okay.
Would it be useful for me to offer the motion I just described?
It would.
Okay. I move to grant the city's limited motion to dismiss, specifically as to any standalone FMLA claims in this action, without prejudice to further discussion of FMLA issues that are not standalone claims and relate to city policy.
All right.
I'll second that.
All right. All in favor of Mr. Rubin's motion, please say aye.
Aye.
Any opposed commissioner? Any commissioner who opposes, please say nay. I think the motion is granted unanimously. Thank you. And now, Ms. Bateman, you have issued or sought the issuance of a number of subpoenas, and I'm going to let you argue about why the subpoenas should be issued, and then we'll hear from the city about why they should not.
Thank you again for the opportunity to be in front of you. I am here today to ask the commission to enter a subpoena and for certain documents. I would like to update, though, the commission on some documents that have been produced by the city since this subpoena was filed. We have gotten, number one, a copy of all dismissals issued to employees between December 2008 and the present. I will say that the city and petitioner are sorting some outstanding issues with regard to that, but the city did turn over documents which purport to be these dismissals. We have not gotten any written warnings and any counseling records, and number 2 is written warnings, and 3 are counseling records, and then 4 are suspensions. And those are the things issued in the first 4. So number 1 is off the table because we've got that. We're just dealing with, I think, some details about that which have to do with the reasons. My subpoena was taken as a public records request, and so those documents were turned over pursuant to that statute. That statute asks for documents, or that statute says the city must produce documents, dismiss of the final agency decision letter that describes the specific acts or omissions. And I've raised some questions about whether the documents sufficiently describe those specific acts and omissions, because a lot of times the documents just cite the policy, but they don't provide the acts or omissions that underlie the policy violation. But anyway, I think I can sort that with the city. I think what's most important is number 5. If I had to say I needed anything, it's number 5. Well, not number 5, because that's just citizen complaints. But here's what we filed: an affidavit from my client. He has listed a boatload of employees that he says did things, even if it's true, what's been alleged, which we vigorously deny, that he engaged in secondary employment while on sick leave or FMLA. We vigorously deny that. That is the heart of our case, okay? That he engaged in there's no evidence that he engaged in any violation of any of those city's policies. But even if you were to assume, for the sake of argument, that he did, his argument is that these people did lots worse things than he did and didn't get terminated. And he was terminated. He wasn't even offered a suspension or anything else. So if there's no justifiable cause for his termination, and we can prove that, he wins. In order to prove that, we've got to show what all these other people did, and they didn't get disciplinary action. And the only way to do that is, and before I even had this list for him, I was like, well, I don't even know how I'm going to do this. So that's why I was asking for all these specific things. Now I have all these names. I really could reduce my subpoena to internal affairs records pertaining to all of these employees on this list. And there may be more out there, but honestly, I think that would be overkill. I mean, if we look at the internal affairs investigations into the allegations against these employees, or we determine that there are no internal affairs allegations into these allegations against these people, then I think that takes us to a certain place where we can pursue our case. But without some, quote, discovery, I know it's not discovery, I know it's just a subpoena to get information. Without that information, I think we are, hamstrung in presenting our case that there was no justifiable cause. So I can answer questions if you have any.
Any questions on this point? Go ahead.
I feel bad always going first.
All right. I appreciate your asking me questions. Let me just say that.
I always prefer questions too. Are you pursuing discovery right now in federal court?
Yes.
And
Both the city and the plaintiff petitioner.
And I'm imagining the scope of the discovery requests are similar in federal court and here? Is that, I mean, tell me if that's right. I'm just guessing.
Yes, I think you could say, I mean, yes. I did not have those names when I did this request to the Civil Service Commission. If I had, I would have put those names in there and just asked for, any documentation about allegations made against those people. And effectively, that's really all I want now is documentation about those allegations against those people, either a copy of the internal affairs investigation into it or a copy of their personnel record or whatever there is that would help me figure out, was there any investigation? Did these people do these things and what happened to them?
And that actually goes to my other question, like just reading the subpoena, and I think I'm getting more context now, but just reading the subpoena when I was preparing for this, I was like, wow, that is an incredibly broad scope. And having had to respond to subpoenas like this before, I would worry about the burdensome nature of the subpoena. And maybe, and I know you presented some on this already, but if I'm worried about that, what would your response be?
My response would be, I think that would be completely appropriate to be worried about that. And because of that, I'm willing to, I'll be happy, of course, with anything you give me, but I would be happy with documentation about the people we've listed in that affidavit and the allegations against them and any disciplinary action they got, and whether it's easier to have us come and look at files, if there are paper files. I don't even know how the city keeps its personnel files or its internal investigations, IA files. But if they are paper, we're happy to come and look at them. If they're not paper and they're electronic, however, I'm willing to do whatever is easiest for the city. I represented the government for 25 years, 29 years in public records requests and producing documents, and I know this is a pain. I know it is, and I don't want to be a pain. I just need the documents, to look at the documents to represent my client.
Other question, and maybe I should have educated myself on this first, but a lot of these personnel records are confidential under state law. And if the city, and sorry, second part, and then you can answer both. And if the city says, and I'm not presupposing what the city says, that the statute, many of these state statutes require a order signed by a judge, and we're not judges. So in that instance, what is your argument? If I'm right on the statute, first of all, and then do we have authority in those statutes to even grant a subpoena on those records?
Here's what I would say to that. I did offer to sign a consent and protective order with the city agreeing to do that. If we're agreeing to keep it confidential, then I think there's some mechanism, at least there is under the Administrative Procedure Act, for going to the Superior Court and getting a judge to sign it, especially if it's a consent order. So if the city were to agree that they would produce these records subject to our agreeing to keep them confidential and using them, only for the purpose of this, not share them with, anybody else, then I think we'd have a basis to get an order signed off by a district or Superior Court judge.
That's very helpful. Thank you very much.
Ms. Bateman, following up on that question, we can't, of course, force the city to consent. Can you hear me?
Yeah.
So you've suggested that because 168A does restrict the ability of the city to produce the records, and assuming that the city does not consent, can you speak about how this commission could issue these subpoenas absent a court order?
Well, are you asking me how you can give them to me if the city doesn't consent?
Yes.
Okay. I think you can just do that. I think you can wave your magic wand and just say, yes, you can have them. You can look at them under these limited conditions. You have to agree to keep them confidential. But you have, you can say that the arguments are clear. There's good cause for those documents to be shown to the petitioner and his attorney, and you have the authority to issue those subpoenas. I mean, your authority is plenary.
And what's the basis for your argument that our authority is plenary?
That you have that authority?
Yeah, I'm sorry. What is the basis for the argument that our authority under 160A is plenary?
And not under 160A. That's the statute under which they produced the public records. We're asking you to use your authority under the Civil Service Act to issue subpoenas.
Okay. All right.
Right. Not 160A. I mean, they could choose actually to deem that it's necessary for the proper functioning of the Civil Service Commission for these records to be produced. They've chosen not to. That's their prerogative. I totally get that. But the reason you have the power to issue subpoenas is because it was anticipated that the city would not give up documents willingly. And it's your authority to say, no, the petitioner has a right to see those or get those under certain conditions subject to your, wisdom in construing the subpoena.
Okay. Thank you. Any other questions for Ms. Bateman?
Yeah, so I've got so obviously we've already kind of agreed that the records from December 8th, 2008 until present would be a lot of records, right? Presumably hundreds, if not thousands, and so I think it would be a little bit easier to get over the privacy concern there because you're looking at an aggregate of hundreds of people. But now that the petitioner has listed out 25 people, so my that raises privacy concerns in my mind a lot more. And so if you were able to get the records that you're requesting for these 25 people, like how are we going to protect their privacy when you would have to bring up, like we have an affidavit here that is public record, how will we protect their privacy if all of these allegations in here are true, and that we're talking about specific cases of this person wasn't fired because of this reason, this person wasn't fired because of this reason, or disciplined, or et cetera, how would we protect their privacy when we now have a list of those 25 individuals?
I think that's an excellent question and one that I did not anticipate. And so what I'm going to say to you is this. We could withdraw that affidavit, or you could seal that affidavit, I believe, and we could come back to you with initials for all of those people, and then we could agree going forward to only refer to people by initials or numbers. I think that's an excellent question. I'm sorry I didn't think of that before you.
Yeah.
But I think that's a legitimate concern, and I'm willing to do anything to protect the privacy of those individuals.
Sure.
I did not think about that being a public record.
Right.
So, had I would have submitted that under seal, and I apologize.
Are there other questions for Ms. Bateman? Thank you, Ms. Bateman. Mr. Hodder, do you want to respond?
Yes, thank you, Your Honor. I have a presentation for that.
Okay.
So the first thing I'd like to say is I'd like to object to the affidavit, period. At least the copy that I received from the clerk's office was unsigned. I don't know if you all received a signed copy, but if it was unsigned, it's not even properly before this commission. There was a reference to listed exhibits. I did not receive a copy of those exhibits. Additionally, the affidavit is based on hearsay and rumors. I have been told that this information exists. I have been told this person did this and that. And typically, we don't allow, affidavits are what somebody knows with their personal knowledge. That's what they're swearing to and attesting to, not that they heard through the rumor mill that something seems to be true. As mentioned by Commissioner Moore, the affidavit violates the privacy of individuals, as well as it includes potentially defamatory and untrue statements of employees who aren't here and don't have the ability to defend themselves. And Commissioner Moore asked, how would we protect the privacy if this is all true? How do we protect their privacy if this is all untrue? Which some of this, I believe, is. Mr. Lands is basing his affidavit on things he has heard through the rumor mill, ostensibly, because he doesn't even say who told him. Where did he hear this? The affidavit includes information that is demonstrably false. Mr. Lands claims that he was reassigned after he returned from FMLA to field operations from the DWI unit, presumably as retaliation. However, he was assigned to the DWI unit on May 13th, 2017, prior to him even taking FMLA leave, several months prior, due to discipline for serious policy violations. So, again, unsigned affidavit, not true. And finally, there was a discussion that Commissioner Rubin brought up about 168-168, which prohibits the disclosure of the confidential personnel information. And this is a public hearing pursuant to Section 11 of the Civil Service Act. We know that everything here is public. I don't know if the commission has the ability to seal records. That's certainly not in the rules. It's not in the act. We've never been, frankly, no one has ever asked for the breadth of personnel files that is being requested today. So it's not something that I believe the commission has confronted, or at least not in the 8.5 years that I've been with the city. As mentioned, the subsection A of Rule .0410 of the Civil Service Rules regarding subpoenas required that the commission, the majority of the commission, approve the issuance of a subpoena for documents. Subsection F allows us to object. As mentioned by Ms. Bateman, the city did, although the petitioner did not file a public records request, which he was certainly free to do, he did not. However, having received the subpoena and in an act of good faith and as somebody who believes in transparency, as the city does, I took that as a public records request, at least partially, and we voluntarily provided this, or not voluntarily, that I believe a public records request requires us to produce the date and type of suspensions going back to 2008, as well as the date and dismissals with the final decision for those dismissals, which is what 168-168 requires. The city objects specifically to all the written warnings, the counseling records, any documents in support of those suspensions, and any documents in support of those terminations that are not the final decision, which, again, was already provided. And most certainly, the city objects to the internal affairs files of complaints made by citizens, which doesn't even necessarily mean that somebody was disciplined. The internal affairs unit receives complaints. It doesn't mean that the officer did anything wrong. And I would list that as including the list that we were provided. Maybe some of those people were complained on. Maybe some allegations were made. That doesn't mean that disciplined, and for that affidavit to assume that there was or should have been disciplined, I'm not sure where they're getting that information from. And it really, again, goes to that privacy interest. So should somebody's name be dragged through the mud because an allegation has been made against them when they are a non-party? Again, Mr. Lance, just as a reminder, he has the burden to show that the city's decision was unjustified. As we understand it, as we understand the argument of the petitioner, they're arguing that the termination, or at least in their subpoena request, that it's arguably unlawful for what that what the city did in terminating is arguably unlawful as a constitutional matter. That's really the only legal argument that was the basis of this subpoena, at least in its written form. We're hearing additional arguments today. If that's the case, again, the city doesn't have jurisdiction to look at whether what the city did was constitutional or not. The subpoena cites to the Tully and Molay cases, which provide a constitutional remedy to government employees based on if there is no other adequate state remedy and there has been a violation of the fruits of their labor under the state constitution. That is not what is happening here today. It's very clear that there is a state law remedy for Mr. Land's allegation of termination. He has appealed to the Civil Service Commission. The Civil Service Commission is a body formulated by the Civil Service Act, which is a sessions law. This is the state law remedy. So Tully and Molay are inopposite as regards this particular subpoena request. With regard to the competency of the court to issue the documents, I believe that there was much back and forth previously about that. The case in Brooks sets out what the standard or what the process is for somebody who wants to obtain the confidential personnel records of municipal employees. It is the General Court of Justice or the Superior Court that has the inherent power via a special proceeding under 7A-246 to do that. Assuming the commission did have jurisdiction, apparently under some unstated authority, you have plenary power. Assuming you did have plenary power to do that, that would be an ex parte order that would affect employees who have not been notified or been given the opportunity to be heard. Ex parte orders require evidence setting forth sufficient facts or circumstances to show reasonable grounds to justify disclosure. And that has not been provided by the petitioner, except for the unsigned affidavit based on hearsay. Which I would contend is not evidence of sufficient grounds. And even if the commission, again, had the authority to issue an ex parte order, that would be prohibited under the Civil Service Act. The Civil Service Act, Section 5, says that the commission may not institute any action that will affect the right of other employees without first making all such employees a party to the proceeding. So I understand that the request has been significantly narrowed at this point to 25 individuals, and I would contend that the Civil Service Commission, prior to issuing this subpoena, would have to bring in or allow at least all of these 25 employees, and many of them are retired at this point, to intervene and to file their objection to the issuance of this subpoena. The Civil Service Rule .041 4.0G does lay out when the commission is issuing a subpoena, and if it's objected to, what it can look at to determine whether it's appropriate to grant or deny that request. So does it relate to a matter or an issue? I think for those on the panel who have had experience with employment law, you know that even when there is a request for the confidential personnel records of non-parties, it's still very limited. You have to look at whether the discipline was issued by the same supervisor that issued the discipline to the plaintiff, whether it was a same or similar enough type of misconduct for which the discipline was issued, whether there were the same aggravating or mitigating factors. And so there's been no showing of any of that. There's a mishmash of allegations of what somebody may or may not have done in these affidavits that, first of all, is it even true, or is it just a rumor? And secondly, even if it is true, I don't know how you compare apples to oranges. And the federal courts have essentially made that determination that you can't. And so you have to have the discipline from the same supervisor, which most of these occurred under different supervisors who did not issue discipline to Mr. Lands. The compliance would be so disruptive as to be unreasonable in light of the significance of the evidence sought. And so absolutely, would this be disruptive? Absolutely. And quite frankly, I would say we can talk about confidentiality like we have been, and that the petitioner is going to keep this information confidential, but we've already seen that in his own affidavit, he's naming names and making allegations about what people did. And quite frankly, the city would have reservations about whether the petitioner wouldn't just speak to others outside of the litigation about these matters, even with a protective order. The other is if it's invalid for reasons of law, and we've already discussed 168 as being the law that would prohibit the city from turning over these records absent a court order. The other matter is, I believe Ms. Bateman was asked whether she's requesting discovery. And the city would contend, yes, this is essentially a discovery request. It was made as a discovery request in the federal action that is running parallel to this action. The Civil Service Commission or the Civil Service Act just doesn't provide for discovery. And in addition to that, it doesn't provide for a fishing expedition. Even if there was discovery allowed, the petitioner wouldn't be allowed to conduct a fishing expedition. Now, even if the request is limited to the 25 people as we heard today, it's still not limited to the same decision maker. It's not limited to being subject to the same standards. There are different policies, different rules with policies. As we heard earlier in the last case, there's a zero tolerance policy for a police officer who is arrested for DWI. The obvious reason for that is if you break the law, how can you be trusted to enforce the law, right? So that's going to be a more serious standard than somebody who is disciplined for being responsible for a vehicle crash while they're sober, just maybe not paying attention. Again, the affidavit does not distinguish between different types of conduct, which is something that the federal courts certainly look at when they're looking at disparate treatment and comparable conduct, and somebody being treated better who is similarly situated than the person who is alleging discrimination or retaliation. Again, it doesn't account for any mitigating circumstances that would distinguish the conduct. Anyone who has ever had to have the unfortunate task of being an employer and meting out discipline knows that there are particular facts and circumstances that distinguish. You can see from the outside that two people committed the same infraction when in fact somebody has maybe a disciplinary history that has gotten them to the point where they probably should be terminated, whereas the other person, maybe that's the first time they've committed the infraction and maybe they get a second chance. And so those are all factors that go into play, at least in federal court, when the court can decide whether a discovery request is overly broad or whether it's relevant. So in summary, Mr. Land's legal argument of basing it on constitutional grounds, it's just irrelevant due to lack of jurisdiction. 168 prohibits the release of the requested records. Section 5 would require the commission to make all employees disciplined or investigated to be present and to be able to have the opportunity to be heard before the subpoena is allowed. The rule itself prohibits the unreasonable disruption or undue hardship or anything that would invalidate the subpoena due to a point of law, which 168A, 168, and Section 5 of the Civil Service Act would be. If the commission has any questions, I'm happy to try to answer them.
Are there questions for Ms. Tejada?
I'll go first so Commissioner Rubin doesn't have to go first this time. I have a couple questions about this affidavit from the petitioner. So if I heard you correctly, the information that you've already turned over to the petitioner is public record. Is that correct?
That's correct.
Okay. So out of his list on this affidavit, we have the name column, the behavior column, and then the City of Raleigh records column. What information in those three columns is included in the information that you've handed over? Were the names included of the people?
So what the public record requires is the name of the person,
Okay.
the date.
Okay.
If it's a suspension, so suspensions and dismissals are treated differently.
Okay.
If it's a suspension, it would be the name, the date, and that the person was suspended, and that's it, not why they were suspended or any of that.
Okay.
If it is a dismissal, then it would be, yes, the person's
Okay.
name, the date, and then the final decision, which could be, so if the final decision, typically if it's an internal affair, if it's termination, it will typically be an internal affairs matter, though it's not required to be.
Sure.
But let's say it's an internal affairs major who makes that initial adjudication of termination. If that's not appealed, then the final termination letter issued by the major becomes the final decision.
Okay.
However, there are levels of appeal, as you all know, that can be appealed to the deputy chief,
Okay.
and that can be appealed to the city manager. And so depending on where the final decision is made from the administrative process, that would be the final decision. And then the final decision also has to include the specific acts and omissions. So there were a couple of places where the city manager made the final decision but didn't articulate what the violation was.
Sure.
And so we thought it was only fair to go back one and provide, oh, here's the termination
Sure.
letter, and here's what it said about why this person was terminated.
Okay. I real quickly, I think we have jurisdiction to do this. If I don't, correct me, but I make a motion to seal this affidavit since it contains personal information. As an administrative, aside from whether we grant the subpoena or not, I think it's important to protect these people that have been thrown into the public sphere.
Well, and I don't know what the precedent or the basis for our ability to seal or not seal. Ms. Tejada, do you have a view on that?
I do have, my view is that there isn't any authority that I'm aware of in the act or in the rules, and for that reason, I don't think, but there is Section 11 of the act which says that these proceedings are public, so I don't know that there is that ability. I what my argument would be if, let's say, a member of the public is here and wants a copy of this document that unfortunately was filed. My argument as someone who, let's say it wasn't a conflict of interest and the city clerk asked me what to do about that, I would say absolutely not. These are personnel matters, and I would advise the city clerk not to turn it over as a matter of under 168, 168.
That was going to be my question, was whether we might consider this to be personnel records and treat them
That would
accordingly.
be my opinion, not having done the research on it, but based on the sensitivity and nature of it and the fact that these are potentially personnel files or certainly invoking personnel files, I would invoke the authority of 168, 168 and protecting them from release.
And so, if you have a view about what the commission can do at this point with regard to the affidavit, let us know what that might be.
The commission certainly could accept Ms. Bateman's offer to withdraw the affidavit.
Ms. Bateman, does that offer still stand?
It does still stand to the extent that I'd like to substitute it with initials, an affidavit with initials. But, I mean, here's the thing, is it all right to speak
Yeah,
from
go
here?
ahead.
Okay. And I do have some other things I'd like to say in
And you'll have an
response to
opportunity.
the city's arguments, but that affidavit is the only basis we have for narrowing down our request. Otherwise, you know, we believe there are many individuals that have not been dismissed. And that's the core of our argument, is that why would you dismiss Mr. Lands for X when all these other people did Y? It may, in fact, be rebuttable by the city, you know, on an individual basis, given circumstances, but if I have to have some affidavit in the record to show why I asked the commission to issue the subpoena. And I'm happy to substitute out another affidavit with just initials.
So I'm going to request at this point that we table that motion
Okay.
until we make a decision on the subpoena itself, and then if we decide, then once we have decided about the decision on the subpoenas, then we can address again the issue of the affidavit.
And Your Honor, I don't know if you can undo what's been done, but again, I don't know if the clerk received a signed copy of the affidavit, but if something that has been unsigned has been filed, I don't know that it was properly filed in the first place, and should it even be accepted?
I think we filed a signed copy, and I apologize if you didn't get one. I mean, we filed, I don't know why yours wasn't signed. Is the one the clerk has signed?
What I have is not signed.
Well, that was an error on my part because I have a signed one.
It
So-
could be
and
a
I'm happy
fortunate
to-
error in the sense that.
So perhaps it's not properly filed and shouldn't be
Well,
filed.
That was a clerical error. It's just picking the wrong document. I mean, we have a signed affidavit, I promise you.
Okay, so let's take up the issue of the affidavit separately and after we rule on the motion to dismiss. Any other questions at this point for Mr. Hada?
No, I'm done with my questions.
I have a couple, and just I'm trying to work through what I think we should do about this, and I'll just tell you what my concerns are and what I'm kind of thinking, and you can let me know your thoughts on it. Would welcome from opposing counsel as well. I'm uncomfortable with this commission issuing a subpoena when we can't seal the documents that would come out of it. There's a reason, I think this is the reason that a judge is required for these things, because when a judge signs an order like that and you violate it, you get held in contempt. If we give a subpoena and somebody, you know, spreads the documents around, I don't think we have any contempt authority. I hope we don't. So I say that to say that I feel like this request is properly put to a superior court judge for an order that would order, if the judge agrees, would order the city to provide whatever documents, and then would provide rules for how they have to be cared for, and including it might be an order that we seal them, at which point I'd be very comfortable that we have the authority to if a superior court judge ordered us to do so. is that, so otherwise I'm concerned with ordering to turn over these personnel records. I'm concerned with whether we have the legal authority to even do that, but I'm also concerned, even if we do, with the propriety of doing it in these circumstances, and would just welcome your response and on rebuttal from opposing counsel.
So I agree, and I believe I articulated earlier before that based on Henry Brooks, that the court has spoken as to the Superior Court essentially through a special proceeding having the inherent power to issue such an order, and the court can order whatever limitations it deems appropriate to protect the confidentiality of non-parties. And the federal court, who has dealt with 168, by the way, has also been concerned about the issue of, even when it has ordered the defendants, the municipal defendants, to issue the discovery, has also been concerned about the privacy interests and has, ordered that. I would agree that probably if the court ordered the sealing of it, that that would likely be sufficient to protect the non-parties. Whether it's proper, I continue to contend that I don't know that it is. I don't know that it's necessary for this petitioner to prove his case. If he truly believes that he's been treated unfairly, he should present the evidence he has, not go on a fishing expedition and maybe get lucky and find something. Additionally, in the suspensions and dismissals that have been turned over to Ms. Bateman, there are plenty of people who were terminated for violations of integrity, which at the end of the day is overarchingly. He didn't do this negligently. He didn't violate the sick leave policy negligently. By his own admission in the exhibit provided to the city's response to his appeal hearing, he admitted that he lied by omission, that he knew he was violating city policies, but that he knew that if he asked for permission, that he would get denied his sick leave if he told the city why he was really going out on sick leave. And so in that regard, the integrity violation is significant, and the city has provided the petitioner with various names and of people who have been dismissed for integrity violations. And so there should be more than enough from there to compare about whether Mr. Lands was treated differently than other people who have engaged in integrity violations.
Ms. Tejada, you said something that I wanted to follow up on, which is you said the federal courts have had some concerns. Has the federal court in this FMLA case between Mr. Lands and the city issued any ruling on discovery of other employees?
No, Your Honor. The city was just served discovery requests last week, and so we have not had the opportunity to respond on the request for the documents, the personnel files of the 25 individuals.
But to be clear, there has been a discovery request by Mr. Lands in the city, in the federal case?
Yes, and I believe just looking at the list from comparing the affidavit, the list of the affidavit and the one from the discovery request, it appears to be the same names.
Okay. Are there other questions for Ms. Tejada?
What if it will take, looking at I have our calendar in front of us, it'll be a while before this case is calendared for an evidentiary hearing. It seems to me that if a federal court is going to oversee turning over these documents under its rules, that may be informative to us later on, if you've already turned them over in the federal case, then maybe that simplifies this. Do you think there's any room to just delay this for now, refuse the subpoena at this point, but without prejudice to pick it up later after federal discovery? I don't want to say complete because it takes forever, but
yes. So my basic little primer on the federal requirements of having the same supervisor and all those are going to be essentially our objections to providing the the files for the vast majority of these 25 because they simply were not, they were issued many, many years ago, and not under the same supervisor, not the same conduct, all of that. So that, just to be transparent, that is going to be our objection, and we'll see what the court decides on that. And then we can certainly provide a copy of that to whatever order is issued by the judge to the commission. And if that informs your own decision, I feel that's fair.
Anything else?
No, thank you.
I would like to see the commission not get out of our lane here. You know, we have a specific charter that we have to live by. GS 160A, 168 is very sacrosanct to employees who work here. It's very important, that those protections. And there are only two ways, as I recall in that statute, that the information that's not already made public specifically in the statute can be made public, and that is if the city council makes a finding that the requested information is in the general public good, not the exact language, but something like that, that it could be released, or by order of a court of competent jurisdiction. And we are not, either one of those. And so I'd be very uncomfortable issuing subpoenas here, to tell you the truth.
Ms. Holland, did you have a comment?
I just agree with Mr. McCormick, and I was taking some notes as you were both talking, and it seemed to me, I think it was Mr. Rubin's point, that if it's going to go before a federal judge for a ruling anyway, and whatever protection and protective orders the court might order, then it seems like that would give us some protection from anyone saying that we violated 160A-168. It seems like we're almost conducting discovery in this case that really should be conducted in the federal court, and I think that coming from a background of employment law, the court may, I don't know, but I would predict might well narrow this down quite a bit and say of these 25 people, we don't think these pulling a gun on fellow officers or reporting working at home but not found to be working at home. I don't know that the court would say those are comparable enough to the type of claim that we have here. So I suspect there might be a narrowing of the number of 25 people. So for those reasons, I am not comfortable issuing a subpoena today.
All right, and any other questions from Mr. Hada? I am going to allow you, Ms. Bateman, to respond. Before then, any other questions for Mr. Hada? Thank you, Mr. Hada.
Thank you.
Ms. Bateman.
Thank you for giving me another opportunity to address some issues that I think are important for you to keep in mind. One is that the federal standards, I don't think the federal standards are applicable to the issue in this case, because the issue in this case is not about the mens rea or the intent of a particular person, which it is in federal discrimination cases, in Title VII cases, in ADEA cases, and ADA cases. The court is always looking to see who made the decision and why. And that's not really the issue here. The issue here is whether the city as an entity had justifiable cause to terminate Mr. Lands. So I would disagree, respectfully disagree, with the city's position that who these supervisors were and what they thought and what they did and when these decisions were made is relevant, because the city is the ultimate decision maker here, and the city is responsibility. It's the city's responsibility to treat its employees with justice, justifiably, to treat people equally and the same. Now, if this were a discrimination case, and we said, and Mr. Land said, and I argued earlier that I think it is essentially a discrimination case, that other people were treated differently than him, but if it was, say, a race discrimination case, a petitioner would come in here and would say to you, Officer Smith, who is white, was not discharged and did exactly the same thing. And that information would become part of the record. Day in and day out, over at the Office of Administrative Hearings in administrative tribunals, which are also public record, personnel records come in all the time. I'm not even asking for that. I think I've agreed to, somehow redact that affidavit, give you initials. I'm agreeing to work with initials through the duration of this case. But the essence of petitioner's case, and the only way he can make it out, is to show that other people were treated differently, that other people didn't get the same cause as him. Didn't get the same disciplinary action as him. So I would just, one, tell you the issues are not the same in this proceeding as they are in federal court. I would say, secondly, there are no constitutional issues necessarily that are behind the subpoena. Yes, if the city acts arbitrarily and capriciously and treats one person differently from another, that might have some constitutional import in another forum, but what that shows in this forum is that there was no just cause. The whole point of this hearing is for him to be able to show there's no just cause, and the burden is on him to do that, and he can't do that without this information. And all he has right now, that affidavit is admissible not for the truth of the matters asserted in it, because it is clearly hearsay. It is submitted to show that he has some basis for believing that other people have been treated differently, and so he's seeking the information that will either rebut or confirm that suspicion. Under Section 5 of the Civil Service, under Section 5, the city argues that all of these individuals would have to be brought in as a party. I think that's not a fair reading of Section 5. What Section 5 actually says is that the commission shall have the authority to affirm, modify, or reverse as it deems necessary those actions over which it has jurisdiction, provided, however, that the commission may not institute any action that will affect the right of other employees without first making all such employees a party to the hearing. I think that section is intended to go towards, for example, a denial of promotion situation where another employee got a job, and the commission might say, okay, we're going to bump the person who was in that job out to give that job to the person who was discriminated against. In that case, I think this section was intended to have that person be made a party to this hearing. I don't think this section has any relationship to the section which deals with subpoenas, and that section is Section 7. The commission is authorized to issue subpoenas upon a written request by either party. When such a request is made for all these things, the commission shall issue it forthwith unless it doesn't relate to a matter in the issue, or it's not described with sufficient particularity, or for any other reason sufficient in law, the subpoena is invalid. So I would submit to you that you do have the authority to issue a subpoena, because that evidence is relevant to petitioner's case, and it can be issued even by authority of the Superior Court judge under a protective order. So I just would like to say, in closing, it's not a fishing expedition, even if it ever were one, where we're looking for certain specific records for certain specific employees. And I think where the rubber hits the road is not where the city admits that it dismissed certain people. Where the rubber hits the road is where there's evidence that they didn't dismiss certain people. And that is not evidence that's been provided to petitioner. So, thank you.
Thank you. And we'll, now is the time for the commissioners, if you have further discussions or motions to, for that to take place.
Well, I have a motion that we not issue these subpoenas, and the reason is because, as I said a while ago, the statute lists two ways that this information, and I don't dispute for a moment that this information could be critical to Ms. Bateman's case. Probably is. It's just how to get it is the struggle here. And I don't believe that we have the authority as a board to create a third way in Chapter 168 to get this information. So I'm happy to make a motion now that we don't issue these, or if somebody else has a different variation of that they'd like to put on the table.
I'll second.
Okay. Any further discussion on Mr. McCormick's motion?
I would just say I agree with exactly what Mr. McCormick has said. I just don't think we have the authority. And then, as I stated earlier, even if we had the authority, I have some concerns about our ability to protect that information absent a court order, which is probably why we don't have that authority. I would just say, though, that in voting for this, like Mr. McCormick said, that information may be relevant to your case. I'm not suggesting that I don't think that there are other avenues that you could pursue, like a special proceeding in Superior Court. And I have no doubt that if a court issues an order that affects this commission, the commission will follow that order. But I think you need that order. Otherwise, we're unable to protect very important confidential information under our current rules.
To that end, I'll withdraw that affidavit.
Okay.
And replace it with a redacted one.
Okay, and we'll take up the affidavit after the vote.
Okay. Oh, sorry.
That's all right. We have a motion on the table seconded to not issue the subpoenas that have been requested and to uphold the objection by the city. All in favor of that motion, please indicate by saying aye.
Aye.
Aye. Anybody opposed? So the city's objection to the issuance of the subpoena is sustained. And now I think we can take up the matter of the affidavit. Ms. Bateman, you had something to say about the affidavit.
Well, I'm happy to replace it with one that's redacted, if that's the commission's pleasure.
And so now that the motion has been denied, I do think there should be some disposition with the unsigned affidavit. And I don't know, City Clerk, if you have any thoughts about how this might be handled administratively.
Am I allowed to have an opinion?
Well,
Courage.
you're encouraged to give us your thoughts.
What was given to me, I did forward to you, and that was what you have was the unsigned. As a notary, things is not notarized, then it's not witnessed or properly done. And as a notary, it would be my opinion that it was a not properly executed document. So take that as you will.
So any other suggestions or thoughts either from the city or Ms. Bateman about Mr. McCormick?
Perhaps it could just be returned to the person who filed it with a notation that this was not a completed document, and then it will be up to them as to whether they want to attempt to file something else.
Ms. Bateman, is that satisfactory?
That's satisfactory to me.
And Ms. Tejada, is that satisfactory?
Yes, Your Honor.
Okay, so let the record reflect that the petitioner's counsel has agreed to withdraw that filing. And if you make other filings, that's certainly your prerogative, but that you will withdraw this filing.
One more time.
Yeah, so with regard to the paper document that was filed, go ahead, Mr.
For
McCormick.
clarification, I'm actually suggesting that the clerk return it as not properly filed rather than.
Yeah.
Thank you for that. So for the record, I think the commission is, and unless I hear otherwise, the commission has agreed that the clerk will return the document to Ms. Bateman. Ms. Bateman, what you do with that afterwards is not before us at this time.
We will have a letter stating that. I'll write a letter saying returning this because this was not properly executed.
Okay.
Perfect.
And I would also just restate the view earlier that to the extent that document exists in emails and record, I would consider that a personnel document. It seems that way to me. And if the city were asked to release it, should evaluate that under the public records law, should comply with the public records law. But to me, it feels like that is a personnel record.
I'll compose that letter today.
All right. Are there other matters before us today that have not been raised?
No, Your Honor, I'd just like to thank everybody for your time. I know you're a volunteer board, and it takes a lot to be here, so thank you.
And Mr.
One
yeah.
housekeeping matter, please.
Yes.
As you know, the petitioner who, for the hearing scheduled on August 17th has withdrawn. Human Resources has taken that opportunity to ask that you retain that date on your calendar so that he could have you review some policy regarding recruitment and onboarding folks. So there'll be 3 policies done, and that should not take over, like the last one, maybe an hour or so.
Okay. The Commission okay with holding that date still and using that date for a review of personnel policies? Is that the question?
That's it, yes.
I think that's satisfactory from my perspective, unless somebody has a problem with that. Okay, thank you. We'll do that. Thank you, everybody, and this hearing today is adjourned.